I met
Yeah. Now, remind me who you're clerking, Judge Jones?
Mm-hmm.
Okay, that's right. How to keep you all. And are you clerking for Judge Lowe? Okay. One person I don't know.
Yeah, this is Will.
Okay.
Bill and Will?
Yeah.
All right. Got it.
Yeah. Tricky. And Will's clerking on the 7th Circuit for
Judge Bauer.
Oh, and Allison popped in, but she'll be right back. And she's clerking for justice.
Nice.
Yeah, it's a diverse set of experiences. We focus mostly on, appellate,
You're going to be on trial.
yeah.
Yeah, but don't worry, you'll get your Social Security and bankruptcy appeals. Actually, I know what Judge Babcock does. Yeah, I wouldn't like to.
Then if you're all like our send back.
Never mind.
That's the way to do it, right?
Yeah.
Okay, so let's go ahead and get started. It's great to have everybody here. And obviously, we have our guests today, and I'm excited to learn from them and have you all ask some questions. Does anybody have a draft for me today? Some people were
Oh yeah, I didn't hear your name on it. Sorry.
one of the advantages of being in a smaller class.
Trying to figure it out. So I'm bad at this.
Yeah, so, yeah.
You're rough.
Okay, no, that's all right, I'm gonna try to keep track of the whip with you guys. So just looking forward, Julie Nichols was gonna come this Wednesday, but then it turns out that she can't, so what we're gonna do is next Monday is Judge Jones coming to the class, and then it looks like Julie will be able to come the Monday after that. So this Wednesday you guys have free time to work on your writing. Because I unfortunately will be out of town this Wednesday. So what I want to do is just kind of shift some things around. So you all will work on your writing, theoretically during what would be your class time on Wednesday. And then instead of having individual conferences at the beginning of 422, we're going to switch those for the end of next week. Okay, so we'll talk about that in a little bit. And then everything else should stay pretty much the same. So, why don't you guys just introduce yourself, even though you know most of the folks here.
Right, sure. My name is Kevin McAdam. I went to CU Law School. I graduated in 2010. And then I clerked for Judge Webb on the State Court of Appeals and have been for the last 18 months with Judge Arguello on the U.S. District Court. So I've seen both the appellate and trial levels, and happy to answer any questions that I can, to the extent that there's specific things that you guys would like to hear about. Both Alexis and Kira interned in the same semester a year ago, right? In the spring, last spring. Yeah, so they also know, at least as far as Judge Arguello goes. They can correct me if my memory is faulty on any particular things, but anyway, that's it. Obviously, having gone through the clerkship application process and now having done it, I have my own thoughts, but they're just mine. So to the extent that they're helpful, great, and otherwise, feel free to pass on them.
Yeah, same on that note. My name's Alex Harp, and I clerk for Judge Fox on the Colorado Court of Appeals. This is my second year of a 2-year clerkship, and I will be clerking again starting in August for Judge Haggerty, so federal magistrate. So I can't really speak too much to that since I haven't experienced it yet. But
That'll work.
Yeah. So, yeah, it'll be a little different pace, different workload, different jurisdiction. So still clerking, but a lot of differences. And I graduated from Cornell Law School in 2011. I actually spent a semester as a visiting student at DU.
What did you take that semester?
Took criminal procedure. I took ethics. Corporation.
And a little bit of time off. So.
Trial ad.
Cool.
Yeah.
Cool.
I know.
Great. Did you have Susannah for corporations?
I had an adjunct.
Okay. Yeah, no, they're sort of filling out the commercial law department, but. Okay, so what I wanted to start with, actually, to give these guys a little bit of context, was to have you guys talk about this class and sort of basically the themes that we've talked about in the class very briefly, and sort of the methodology that we're working with in terms of the problem stuff. So
Could I add to that too? Just again, if you tell us who you're clerking for, and then I'd be interested in knowing what you want to do, after your clerkships, if you have any ideas. be helpful.
Great question.
I'm clerking with Judge Jones on the Court of Appeals. And I'm thinking at this point after that I'll probably just be looking for a civil litigation job. Definitely want to do litigation, but beyond that, I'll have 2 years to think about it. And I'm talking about the class?
Go right ahead.
Okay.
Pick a theme, any theme.
We started with kind of broad themes about sort of the ethics of judicial decision-making and kind of what goes into that, kind of when we're honest about that and not honest about everything that goes into those decisions.
The sort of realism, formalism divide.
Yeah.
Which, some might characterize as
Professor-
being about honesty or.
Professor Pollvogt is a big believer in formalism. She has much more faith, I think, than I have in anything. But
I think working with a judge is going to cure you of that. I think you're going to be very optimistic about the law when you come out of it. So.
That's a look forward to that.
My name is Alice Malteris. I'm the clerk for Justice Hobbs in the Colorado Supreme Court. I think this is kind of fitting that I want to practice water and land use law when I finish working with them. So
Nice. Do you want to write poetry also?
I was an English reader, so I really appreciate it.
He seems like such a nice guy.
He is. He really, really is. And I'm on the poetry listserv, so I get a couple of in my email inbox every week. Highlight. And have you, Professor Poe, have you told them about our simulation for the class?
No, well, I want to get your perspective. I
Oh,
talked
okay.
a little bit, but yeah.
So this is cool because it's turned into something that I talk to with my friends and family and my current job and things like that. And we are tasked with drafting the U.S. Supreme Court opinion in the Susannah case. So we've talked about all the different components of decision writing, from jurisdiction to what the effect of the holding would be on the lower court decisions and the disposition. So yeah, we've kind of gone through step by step with that, and we're in the drafting stage now with our analysis of everything.
Will McAllister, I'm off to the 7th Circuit, look for Judge Bauer up there. After I'm done, I'm considering actually doing like a trial court clerkship once I'm done, just kind of both sides of it. I think that'd be pretty interesting, but at the same time, I might be closer to Bill. At that point, I might just be kind of ready to practice, so kind of seek something out along those lines.
Yours is just a 1 year.
Yeah, just a 1 year, yeah. So I do 1 year appellate, maybe 1 year trial, but we'll see how that goes.
Where is it?
It's in Chicago.
Chicago.
Yeah. So looking forward to looking out there. As far as this class has gone too, I mean, yeah, it's been quite interesting to see kind of just the methods of making a decision when you have such complicated issues, and then working with a live case right now has been great because you get to kind of see. You got kind of almost instant feedback too. Like as we write our own opinion, we can kind of see how it lines up with some of the brightest minds in our country or around the world, and see what their opinion is going to look like. So looking forward to that. And then, I mean, it's been nice to look at a lot of techniques of like how do you really get to this disposition of the issue, what issues should be tackled or just kind of move along with, and then and really sticking to like a formalist type opinion, or that's where like the ethics kind of come in, or kind of a realist approach, or how do you kind of formulate that opinion and get to the answer you want, but also that's legally supported, and also is easy for people to understand and read and kind of benefit from.
So that would be a great issue for you guys to touch on. That, results versus precedent.
Yeah. Yeah. But it's been nice just because Professor, there's so much out there that she's helped handpick a few cases for us to side with, so that's been helpful.
Yeah, so one of the goals is obviously with equal protection law, I mean, there's so much between scholarship and case law and everything else, but to try to have, for purposes of this class, kind of an area of focus. And I think even when you're in the real world, starting with an area of focus and then accounting for the rest of what's out there, but not getting overwhelmed by the amount of source material that exists. Right?
I'm Kira. I'm clerking for Judge Loeb on the Court of Appeals. And going off some of the things that everyone else has talked about, so in addition to the copy, we've talked about, we all were assigned law review articles to read, and we did presentations to the class. And so one article's about the use of legislative history, one was about diversity in the judiciary, and then the tension between formalism and realism. So those have kind of just been, the ethics and the legalism, formalism have been reoccurring themes in our class that we've just been discussing about how to apply that once we begin our clerkships, and different writing styles and trying to, adapt to your judge. Some judges might be more open to citing law review articles, some might be more, formalist and just stick to their case law. So that's really interesting, and I'd be interested to hear how your experiences with your different judges have been.
I'm Alexis. I'm working for Judge Babcock, and after that I'm going to affirm to practice within civil litigation.
Which firm are you going to?
Ryan Cave.
Okay.
I'm doing probably white collar, antitrust, things like that. Something I found helpful as the trial court clerk was we went over kind of which is kind of strange to say that you don't really learn this in school, but the way, how a case proceeds from motion to dismiss, summary judgment, other motions you'll be doing. So I thought all of that was really helpful to kind of give me a grasp of, because I know I wrote motions to dismiss or motions for summary judgment, but at the time I didn't really know what that was.
That's not true.
You might have considered telling us that at the time. Yeah, I think you've been affirmed.
Yeah.
I think that in the snowmobile case.
Yeah.
Yeah. Well done.
And I thought my other favorite piece was the diversity in the judiciary piece. For personal reasons, I thought it was very interesting. They kind of talked about that whether you're considered a liberal or conservative judge and the, statistical results of that in your decision making.
What's Clarence Thomas? Pop quiz. What is he?
Conservative. Isn't he the most conservative? Or one of them?
That's not a judge or
On the statistics, at
Yeah.
him and then Marshall, so according to their really complicated mathematical analysis. Will explain to us.
Well, there's this whole, I don't know if you guys follow this, I'm not sure why you would necessarily, but there's this whole sort of scholarship around judicial behavior that's very quantitative, and I think has some really questionable assumptions, and that was kind of Will's job, was to sort of try to, parse this out and present it to us, but, for me, having worked for the courts and having, gone through my clerkship and staff training period and stuff, I don't know, I take a lot of offense sometimes at these efforts to sort of say, predict judges in a political manner versus seeing them as judges who try to approach each case and decide it properly or whatever. So that's definitely been a theme that we've had here. But that was great, guys. That was a really good description. Hopefully gave you guys some context. If you have a place where you want to judge, I've got a ton of questions for you, and I want you guys to ask whatever questions you want. But if you have something in terms of, especially I'm interested in what you didn't know going into it. Right? When you show up, I'm a law clerk, and maybe you had an intern before, but how did you adapt to that role?
I would say that an appellate clerkship is probably an easier transition, although you can speak to both, and that it's mostly research, reviewing the transcripts, the record, and writing. So those are skills that most law students feel relatively comfortable with. You're not kind of thrown into figuring out where procedurally something fits in. You have time to review the big picture. I think the biggest shock for me was when I realized how many mistakes lawyers make, and really becoming skeptical about the briefs that I'm reading, the recitation of the record that they're giving me.
That's really helpful perspective.
Just not taking it for granted as a correct statement of the law. And also realizing, even as a new attorney, and when I was drafting my first briefs, I wasn't even an attorney yet, I had gotten my bar results. I was very reluctant to question a judge's judgment. Who am I to reverse, this attorney who's been practicing for 30 years, been a judge for 10 years, and, realizing that we have the benefit of hindsight, time to research these issues, and kind of having more confidence in myself to question people who have more experience than you, because as a law clerk, it can be hard the first couple of months to have the confidence to question what other lawyers bring back.
And just a little follow-up on that, what is the sort of orientation of your judge towards the idea of lower court error? You know, I mean, like some appellate judges don't even want to say the lower court because they think that's sort of derogatory or what have you. I mean, was there a culture of understanding that the lower courts are under a lot of pressure and this is why mistakes happen? Or can you describe the sort of, your judge's approach on like a tone level?
On a tone level, we use trial court, lower court. And my judge has been a trial lawyer most of her career, so she really gets sort of being in the courtroom and the pace and how things happen there, which has been really helpful in talking with her about various issues, because her intuition, well, I know I've researched the issue more than she has usually when we chat about it, but her intuition and her gut usually ends up being right once I do the research, just because she has a feel for how things are supposed to happen. But I think we figure out what the standard of review is, and it's usually very deferential. So unless it's de novo legal issue or something like that, we go into it, assuming that they were right, and if they made a mistake, then.
Well, I'd piggyback on that too. I mean, I guess something that I hadn't really thought much about, but it makes sense once you do, is how small the legal community is. I mean, even for state trial judges that are far away, down in El Paso or out in Grand Junction or whatever, these people see each other. I mean, I remember Judge Webb, a year or 2 years before I got there, had reversed a trial judge in some remote corner of the state, and he saw him at a conference later, and the guy was like not happy about it, and like kind of took it personally. And I think that's just an anecdote that's sort of true of the relationships that the judges have. So, I mean, that's, I think, even more true in federal court because there's less judges and they're more centralized. But like, I don't know. I mean, in U.S. District Court, the district judges here don't get reversed that often. I mean, I think it's a testament to the fact that they're good judges, but also, I don't think the judges on the 10th Circuit, they don't look forward to doing that. Certainly it's easier, if it's, an issue, statutory interpretation or some other legal issue. But that was something I hadn't anticipated.
And that's kind of like on an institutional level. You're figuring out what's the right answer in this case, what's the applicable law, but there's a sort of institutional culture around reversal too.
Oh yeah, I mean, and it applies. I mean, this is something that most people, I certainly didn't know that the district court functions this way until I got there. There's a lot of matters that are referred by the district court judge to a magistrate judge. So for example, in a case that's filed by a litigant that doesn't have an attorney, most of the motions that are filed in that case will be referred to a magistrate judge. The magistrate judge will do a recommendation.
It's a lot of work. It is a lot of work.
It is.
Magistrates are workhorses.
No, it's certainly true. But that's a really good example of times when we'll get from a magistrate judge a recommendation on a motion to dismiss or motion for summary judgment. And I mean, we had one recently where it was incorrect. The recommendation, it came to the wrong outcome, the law was wrong, and we dealt with kid gloves with that issue. I mean, very much, because the magistrate judge, not only is a magistrate judge in the U.S. District Court, I mean, it's a magistrate judge in our building. I mean, somebody that we are going to see, we're going to see their clerks, et cetera. And so,
do you think that was a matter of lack of oversight of the law clerk? I mean, just speculating.
I do not know. I don't know what accounted for it. But yeah, I mean, presumably there was some issue that happened, but thankfully, review of a magistrate judge's rec is done de novo, so there's really no reason to drag the magistrate judge through the mud on that one. But yeah, so I mean, that's kind of an interesting thing that, I mean, it works both ways. From the district court level, you'll be thankful that the appellate judges aren't looking to reverse, and then you appellate clerks, I mean, it's something that my suspicion would be you'll find that your judges are reluctant. If there's a way to affirm, they often do. So that was one thing. The other.
Do you guys have any responses to that idea? I mean, does that surprise you? Is that a sort of form of bias in the system that's unfair to litigants?
I mean, a little bit. I mean, there's a little bit of like that, it's not a formalist approach where it's like starting with the law, apply the facts, and come to your conclusion. It's like, all right, we don't really want to overturn this case unless we have to. I mean, it's like.
Well, it is the law, so we're applying the standard of review.
That's right,
Yeah,
that's a good,
unless there's a de novo, or de novo review. Yeah, I mean, it is kind of an abuse of discretion for most of the matters.
Yeah, so it's sort of, I mean, it's both,
Built in a little bit.
it's built
Yeah.
into the system, you know, in terms of the standards of review, that you don't want to be willy-nilly overturning trial court decisions, but then there's also this kind of, you know, fraternal, whatever you can say,
Oh, yeah.
aspect to it. So,
Yeah.
okay, go ahead.
That's it with you. The other thing I was going to say was, yeah, just from a practical perspective, this applies much more to being at the district court, but the volume of work is kind of overwhelming, and figuring out, I mean, there's a lot more moving parts, I think, at the district court level. I mean, at the Court of Appeals, I don't know how Judge Fox divvies up the cases, but I would basically get 2 cases a month. I would have 2 weeks to do the first one, I'd have 2 weeks to do the second one, and then it would start over again the next month. And if I got ahead, sometimes we'd get a case pre-assigned, and I could start working. I mean, there was one point in time where I think I had 6 or 7 weeks to do one opinion, and that was a lot of time. The district court, I mean, you can never, like, plan. I mean, even like the next day, I could come into the office tomorrow and find out that a preliminary injunction or a TRO was filed today in some case, and everything that I had planned for the rest of the week is out the window. And that happens actually with somewhat great frequency. I mean, for a senior judge, I'm not sure, and Judge Babcock kind of does like separate other functions. He does a lot of screening and stuff, so you'll probably avoid some of that, hopefully. But yeah, that aspect of it, I think it's very true to practice. I mean, so I've been told, you know, something gets filed in your case or you get an unfavorable ruling. I mean, you don't know when those things are going to happen, so.
Right, it's a
Yeah.
lot more like being a litigator and a trial court litigator,
Yeah.
right?
Yeah, I mean, so to the extent that any of you are considering, you know, a future clerkship, I mean, there is definitely, I mean, that's one of the many ways in which a trial court clerkship is different than an appellate court clerkship. And I mean, I want to go on to litigate, and I'm thankful for having had the opportunity to learn to juggle all of these things at the same time. I mean, it's simultaneously the best and the worst part of the job. It's a good skill, but it's a tough one to learn.
Can you guys talk about the decision to do another clerkship? I thought you were headed to the TA's office.
That was if I wasn't going to clerk.
Okay.
That's next on the agenda. 3 years.
I wish I had a plan like this. Right?
Well, it's actually sort of funny. All my clerkships, and this is probably heard this before because she interned with Judge Fox. All my clerkships kind of came about in a weird, untraditional way because I interned at the U.S. Attorney's Office while Judge Fox was there, and she was appointed as a judge while I was working there. And I hadn't applied to clerkships. I just,
That happens.
I don't know, I knew I was moving to Colorado. I thought it'd be kind of a crapshoot, and I didn't really think I'd have a great chance. I didn't really know what I wanted to do. So, yeah, she told me I should look and see who was still hiring. There were still, it was, you know, maybe October, November, there were still a few appellate court judges hiring. So I applied to her and a few other judges. And fortunately, I worked for her already. So she could just talk to anyone at the U.S. Attorney's Office to find out if, you know.
You showed up for work.
Yeah, if I was doing what I was supposed to be doing. So that's how I got the first one in. Originally, she was a new judge, so she was planning on doing 1-year clerkships. And I thought I was just doing 1 year. And when I started with her in August, I thought I'd apply for what I thought most federal judges did 1 year in Colorado, but apparently most of them do 2 years. So I applied. I only applied to a handful of federal judges in Denver, sort of just was like, if I'm going to do it, I might as well do it for somebody that I've heard is really fun to clerk for. So I applied, and I didn't get a clerkship. So Judge Fox asked me to stay for another year. She decided to do 2-year staggered terms, and I did. And I didn't want to reapply. I was like, I don't know if I want to clerk for that long. I don't think I'm going to resubmit my applications. But one of the judges I'd interviewed with, Judge Hegarty I'd interviewed with before, called me and said, are you still considering a clerkship? And I was like, oh.
I am now.
I was like, yeah. So, yeah, it was kind of an odd situation, but I I did struggle with the decision because I was in a position to kind of say, no, I'm not still applying, don't consider me. Because I was really eager to go to a DA's office. I mean, I had been planning on going to a DA's office now for, since I graduated. So I was like, oh, do I really want to put that on hold when I know what I want to do? But I think that clerking is just an invaluable experience. And like I said, it's different enough at the federal level, at the trial level.
There's
at the
value
magistrate
added,
level.
you don't want to, there is such a thing as
Yeah.
clerking for too long.
Definitely.
But when you're acquiring different skill sets, I think that doesn't matter.
That's kind of what it came down to. I mean, I think any longer than 2 years, for me at least, at the Court of Appeals level, I probably would max out on how much I'm really gaining from it. I think 2 years is great, but beyond that, you're still seeing new issues, but I think in terms of the learning curve, you're kind of plateau. So.
Yeah. Yeah, for me, the decision, I wanted to do both. And so I applied again. And it's so much easier the second time around because you've done it already. I mean, you have all the materials, just everything about it. There's a sunk cost, I think, unless you got your laptop stolen or deleted it or whatever. But, for me, the second time around was a lot easier. I'd already done it before, so I knew how to get the materials
Was your
out.
judge a reference for them?
No, because, there wasn't much that he could say,
So you
really.
did 1
But
year, yeah.
yeah, I applied, when I was at your guys' point, towards the end of my 3L year, I applied to Judge Arguello.
Okay.
Yeah,
right.
for the year after.
Right.
Yeah, but it was definitely helpful. One of the reasons she hired me, she told me, was because I would come to her having clerked at the appellate level for a year. So, that already having a clerkship, it will become substantially easier if you want to do a second one. But yeah, there is a point, I would add one caveat to the comment about clerking for too long. I think going into government service, that's probably true. I've been interviewing at firms and have been told in a couple of different places that my window for moving from the clerkship world to the law firm world is rapidly narrowing. So, a lot of firms, especially the firms that have summer classes, they look to see when you graduated from law school. I graduated in 2010, and so, in the fall of 2013, where are they going to put me? Am I going to come on as a fourth-year associate? Unlikely. I don't have 3 years of associate work. I have certainly 1, maybe 2 years of transferable skills, but there comes a point at which, I haven't taken a deposition, I haven't argued a motion, et cetera, et cetera. So there comes a point in time where you gotta, I think, cut it off if you want to go to a firm, and particularly a firm that has summer classes. Other firms, like Weaver Trigg, they don't have summer class, and they take, clerks and laterals all the time, and they're kind of a little untraditional in that respect. But
is that something you can negotiate with them? That you can negotiate? I'll come in as
Yeah, well, I don't know yet.
second year rather than fourth year. Or...
It's just weird. There's just so few people that come after having clerked for more than 2 years. They see 1 year clerkships all the time, and they often see 2 years for people that do trial and appellate. But after a third year, they're kind of unsure as to what to do with you.
That's interesting. Yeah.
Yeah, certainly beyond that.
Though I wonder if that's going to become more common because, like I said, I always thought it was 1 year was the standard, and maybe that's just on the East Coast. But out here, I found most judges that I've talked to.
I think it's changed a little bit with the economy.
Yeah, I think it's
Yeah.
changed. So I think it's becoming a little bit more acceptable
Yeah.
to do 2 clerkships or to stay an extra year. It's sort of, I don't know, maybe that'll change again. But.
Well, and some people do. I was a staff attorney in Vermont and then the 10th Circuit, and it ultimately was not a good fit for my sort of personality. But some people.
Why? Because you never saw other humans?
Yeah, it was really. It's very cloistered.
Yeah.
It's very, very cloistered. Very sort of cerebral. But that's a great job. If that's your personality, that is a fantastic job. And so some people really, they do their clerkship and they feel like this is the environment I like to be in. I like to be kind of behind the scenes, writing, thinking, solving problems and whatnot. But it is, there's sort of there are 2 different worlds, between private practice and clerking. So. I wanted to ask you all about decorum. I don't know if that's a phrase that or a word that your judges used a lot. I think now I'm going to be like crotchety old woman, but I think that sort of generationally, I feel like the idea of decorum is even less familiar to maybe contemporary law students than, X number of years ago or what have you. Is that something, tell me about your experience with that.
Yeah, I mean, in the trial court, we see attorneys a lot. I mean, at the Court of Appeals, it's like if there's an argument, you'll see people, but, yeah, I mean. So,
and you're interacting with attorneys directly.
Yeah, I mean, on the phone,
Yeah.
They come in to set trials with the judge's secretary, we're in the courtroom for hearings, so, I mean, there's a lot more consideration as to how to dress, what to say in the presence of other attorneys, et cetera, just because you're around them more frequently. But
so
I
it's
mean,
kind of professionalism, but also ethics and confidentiality, right?
Yeah. I mean, no one's gonna. Well, I shouldn't say that. It's unlikely that somebody would, say something, about a case that they shouldn't. But it's more likely that, at the end of a hearing, I get up and go start talking to the AUSA that I'm friends with and realize this looks extremely improper for the judge's law clerk to be doing that. I mean, we had that scenario come up with an intern actually. He just hadn't thought about it, and
Well, I think it's a different way of thinking. It's something we've talked a lot about. Not a lot, some in this class. Sort of decorum, confidentiality, ethics, and what have you. And how? Who was it that was saying the policy in the chambers is that whatever's improper for the judge is also improper for the clerk? Was that?
I think it's.
Okay. But sort of, I think that's a really radical transition from being a law student who's just thinking about ideas and talking about things, and you don't have that sense of responsibility, and then going and being a law clerk. I think it's just something that one has to adjust to.
Yeah, I mean, I think one thing that's true is you guys will all congregate with your fellow clerks for lunch or breakfast, or you'll hang out, you become friends with your fellow clerks. And I'm always surprised at the types of things other clerks say that I think are probably meant to be kept within their chambers.
So inter-chambers relations.
Yeah, I am pretty loath to talk about things that happen within our chambers. It's actually, I think this pertains more to some of the career clerks, and they've been there for forever, and I think they feel a little bit more at liberty to do that. But
Can you give an example?
I mean, just stories. I mean, there's a career clerk in the district court who spent like an entire lunch telling all of us about all of his co-clerks that had previously been fired and the scenarios under which his judge had fired them, which, I mean, I think to a certain extent was kind of public knowledge because people had been around and they knew these people.
Weird, definitely.
But yeah, and that one wasn't that bad. But I mean, there's things like that it's probably. I mean, if it's something that you wouldn't say in the presence of your judge, then yeah, it's probably
that's a good test. Yeah.
Right. But I mean, I think it has its limits, and I mean, everyone kind of uses their own discretion. That's something that I was surprised kind of right off the bat at some of the stories that I had heard that seemed like they were kind of not improper, but just I wouldn't have been comfortable talking about my judge or my coworkers in that same way.
Did your judges have a conversation with you guys? I mean, obviously about like gossiping about your judge, like your judges are gonna be like, oh, that's fine, please do that.
Yeah.
But just about like talking about cases, for me with load, I won't have a co-clerk, I'll have a judicial assistant. So just as far as like, did your judges tell you like, you can discuss like broad legal concepts with other clerks, or like just don't talk about cases, or how specific, or is that something you kind of had to feel out on your own that your judge didn't really tell you?
I don't remember if I had like a sit down with Judge Fox about this or not, but I think it really varies from judge to judge, and that's what I've heard from other clerks. Judge Fox, I think, is definitely on the more you can talk about whatever you want end of things. I think she almost encourages it if we need someone else to bounce ideas off of. Especially if they're not on division. I mean, if they're on division, sometimes that can get a little tricky because, the other clerk's judge might be disagreeing, and then, they feel like I don't know. But she's very laid back about it, but that's just my judge.
Right.
And I know other judges aren't like that, but.
Yeah, I mean, that's the kind of thing that's good to ask early on. I mean, Judge Arguello, she told us, mostly because she had inherited 2 clerks from Judge Nottingham, and Judge Nottingham didn't allow his clerks to associate with other clerks. And, which, I mean, that was publicly known, but, I mean, on Judge O'Grady, it was like first or second day, one of her clerks was like, can I talk to, we just inherited this case from another chambers, I'd like to talk to the clerk, the case has been open for 3 years, like, they've done all this work in it, and Judge O'Grady was like, why are you asking me? Like, well, because we couldn't with Judge Nottingham. She's like, yeah, totally, so that was something that, both of those perspectives, I mean, they both exist. I don't know that they're necessarily both valid. I'm not sure I understand the prohibition on talking to other clerks, but it definitely happens.
Well, we had an interesting conversation with Justice Marquez about sort of transparency and, the sort of tension between transparency and decorum, because it's sort of, just for, I don't know, for whatever reason, my feeling is to keep it really tight, sort of, circle in terms of things that you talk about with your judge and what have you, and not talking to other clerks about your decision-making process within chambers.
Mm-hmm.
But then at some point you sort of ask yourself, well, why?
Mm-hmm.
What's the risk involved, I think it sounds like there's maybe some evolution on the part of judges too, that's maybe a little bit of a generational shift.
Part of it. I mean, I like talking to other clerks about how they do things differently, and I think it's interesting. I mean, I don't know if I necessarily do much with that information, but it's good to hear how other chambers operate, and there's other ways to do things, especially when, this is my first job, this is my first boss. It's good to know there's a lot of other ways to.
But obviously, right, never undermine, never say something that undermines your judge. It's not like another job where you might go and complain about your boss or something.
Yeah, I think it's super easy with me because I love working for
Right.
Judge Fox.
Right.
I think it would be a very different situation if I didn't.
Right.
Then I would have to be a lot more careful.
Right.
But I'm not in that situation.
I bet everyone here is interested in hearing why people do get fired in the clerkships. If you can speak very generically, because we have no idea who you're talking about.
Yeah.
Has anyone ever been fired from the Court of Appeals? I don't know them.
Yeah. I mean, two that I can think of, but both before my time, but I heard the stories. This friend of mine who's multiple co-clerks have been fired over the years. I mean, for some of them, for like really obvious reasons. There was one that they kind of found out, apparently, that the guy's wife was doing all the work. He would like take his work home, and she was doing all of it, and like they found out because they would cite. He would do some work, obviously, things that had to be turned around in the same day, but they would cite the record differently. And there was always this difference, and they picked up on it after a while that the crappy work was cited, the record was cited to in one way, and the good work, the record was cited to in another way, and they knew he was doing the one that cited the record in the one way, and so, I mean, they assumed that it was the wife. Apparently she was quite smart. She was also an attorney. So that's one, not doing the work yourself.
And I feel like none of us would fall into that.
My husband would never fall into that situation. Do it yourself.
I mean, that's an obvious one. One other that I can think of, this came to light afterwards, after she had been released. The 10th Circuit reversed in a case and said you didn't address qualified immunity, and it was raised. That was kind of indicative, I think, of like what had been going on. Was like, I think there were sometimes issues. I mean, that's not necessarily a particularly complicated issue, but some issues that were overlooked, that were purposely swept under the rug, whatever. But I think you'll find by the clerk, and you'll find, I mean, at least, especially in the district court, just because of the volume of the work, I think it occurred at every level. Like Alex was saying, when you go to talk to your judge, at least initially, you will be better versed in the case than your judge is, which is a very surreal experience, I think, to have that person who's, at least in my case with both of my clerkships, way smarter than I am, having me tell them about the case, and so...
Let's actually pause there for a second, 'cause I think that's an interesting idea, and I assume you have a similar experience. And you talked before about how your judge's job is to have the experience and the intuition. Right, and the clerk's job is to be the laboring oar, in a sense, and to be the one who knows the details, and not just the details of that case and the record, but actually the details of that case law. I mean, there are some judges maybe have a photographic memory, but generally they're generalists, and they have good understanding of the law, but they have not necessarily reread the last 10 decisions on, the new summary judgment standard or whatever it happens to be. So to embrace that you are there to be an expert in that case, and to not, if you're sort of dependent and passive, and maybe you guys can talk about that a little bit, but if you're sort of passive as a law clerk or expecting your judge to always guide you, it could lead to some
Yeah,
problems.
well, I mean, I think there's a hierarchy of things that you have to be the expert on, like the things that are filed that you're ruling on, or, at a court of appeals, the briefing in the case, like, be an expert in that for sure. I mean, there's other things, I think the law, it's broader, and there's always going to be cases that you're not going to end up finding or reading or whatever, but like certainly the filings in the case, if you go to talk to your judge and your judge says, did defendant raise qualified immunity?
Good advice.
Yeah, like you'd like to be able to say definitively, either yes or no. And if you don't know, I don't know is also, it's certainly far better than no when that turns out to be the wrong answer.
Well, especially if you're like a lot of students who perform well are sort of people pleasers, so
Yeah.
just be really careful about that.
Yeah.
If you don't know it, say you don't know it, go and look it up. But how did you guys keep track of that kind of information? How did you, in terms of your note taking and things like that? Like, how do you stay on your A game in terms of being aware of everything that's going on in the case?
I don't know, that's a good question. Judge Fox has a very open door policy.
Yeah.
She wants me to come in and interrupt her, which, I would check with your judge before you. But if I'm in the middle of a complicated issue that could kind of go both ways, and the law isn't really clear, it's very fact, something like that, I can go in and say, what was your gut on this? This is what the law is saying, this is what the record is saying, I'm really not sure what direction, and she'll help me with that. So I generally don't have to kind of put things aside and keep track of them and then like, okay, I need to talk to her about this and this. I'll just pop in and
Just very collaborative.
yeah.
Which is nice, and not every coach is that way.
So that's how I do it. I think that wasn't how it was at the very beginning. At the very beginning, I would finish an entire draft opinion and give it to her before I'd talk to her about it at all, usually. I might conference with her briefly beforehand. And that became less efficient as I learned, how she thinks, and I think one thing that's really important is developing strong trust with your judge, because they want to be able to trust you.
Yes.
They don't want to be second guessing you. They don't want to be redoing the work you already did because they're not sure if
So
you're doing it
they're
right.
giving you, as a law clerk, a lot of responsibility. We
Yeah.
talked about this before. I talked this a lot with folks who are applying for clerkships. It's like, what does your judge want from you? Your judge, if you make a mistake as the law clerk, that's going to reflect really poorly on your judge. Your judge wants to be able to trust you, and vice versa. That's really important.
Yeah, and once you make a mistake, the judge is going to be worried that they're
Yeah.
going to have to second guess everything that you do. So, yeah, it's important to build that trust and really earn it.
Which I think doesn't mean knowing everything. It means being
Sure.
really thorough.
And be
Right, yeah.
truthful too.
Truthful.
Say, oh, I haven't read that part of the transcript yet. Let me get to that
Good.
and get back to you.
Good.
I didn't think that we needed to go over that part, that opening statements. I didn't think that was relevant to the closing statements or whatever. I haven't even looked at that. Just being really honest. You don't want to be so unprepared that you haven't,
Right.
But I think that's been really helpful with my ability to communicate with my judge, and that I think that she felt she could trust me, and now I feel like I can really talk to her about things without, her second guessing me or her, so I don't know.
Yeah, I was going to say, it's different. I tell this, Alexis and Carrie could probably testify to this, but I think every semester when we have interns, my co-clerk and I talk to the interns before we start, and one of the things that I always tell them is, unlike law school, where when you get to the end of your paper or your exam or whatever, and you're kind of like, I don't know if this is right, it doesn't really matter. You're going to hand it in, it's going to get graded, you'll probably get a good grade, but, at least from the clerkship perspective, it's not always going to be right, and, eventually everybody gets reversed, but that mentality is much different. You have to be really confident, and not necessarily that you've gotten it right, like from an academic perspective, but that you've been thorough about making sure that what you said is correct. I mean, Alexis and Kira you guys were both really good interns, but I mean, we have had occasions, there have been occasions where for me, I've had to sit down with an intern, and the reason why I'm saying this is because I try to think of this kind of interaction between the judge and myself. I mean, I interact with our interns in the same way that the judge interacts with me. And I've had to say, like, look, when you cite this case, and I pull it up and it's red flagged on Westlaw, like, that's a huge problem. Or when you cite, when you quote whatever this is, from this case, and I go there and that quote's not there, like, we have issues and it makes me second guess your work. And so, I mean, that's something that, we always say, it's much better take more time, make sure it's thorough, and, the quantity of the work will catch up eventually as you get more comfortable with it. But yeah, just making sure that, because, you're fine getting a B+ or a B- or whatever when you hand the paper in law school, but, even if there's a red flagged case or something like that in your paper, but mistakes like that, I think, are much more serious when you're writing opinions or orders.
Because you have that responsibility, right? I mean, you have a lot of responsibility working for the court, and so that accuracy and thoroughness translates into an ethical obligation too. That's a good point too. Just don't cite something without looking at it.
Yeah.
It's really easy. Again, I think in our information culture, it's really easy to kind of, cut and paste things together. You want to look at everything.
I mean, that's something when I cut and paste things that I've written, even just a couple of months ago, because we have a lot of the same kinds of things. I mean, I write the same sorts of orders often and can borrow from what I've written previously. I still, go back and site check everything, because you don't know if
Do
something's
you have to
been
site check
reversed
yourself, or do you guys, right?
Yeah, I mean, we have a program for it, but I do it fairly quickly. But I mean, and that's my own work. Like, if I'm going to do it to my own work, it's definitely. I mean, for things that I'm writing myself, it's important to do it to, when you're going to give that to somebody else.
So this is another, because a lot of times the clerks will trade off, I'll site check the opinion that you wrote or whatever, and this is another situation where you're kind of in a unique circumstance. And so, to be able to carefully edit your own work is really hard for all of us, but that's definitely a skill, that you'll be working on.
I have a question.
Yes, please.
I think you probably will not be able to tell me maybe you can see what other people do, and maybe you'll know a little bit about this. My judge, I have been kind of told or hinted at that my judge doesn't seem to really be a strong mentor for her. And that's something that I want from a clerkship. Is there a way, or have you heard or whatever, to suggest or kind of build that relationship, because I don't want to just be. My clerk said things like he would go 3 or 4 or 5 days without seeing his judge, or that he just doesn't. He says that if you ask him a question, then he will help you, but it's never. I also don't want to.
Right. Yeah. Well, I mean. So you're talking about developing a relationship with your judge.
Yeah.
I mean, because the easier.
Seeking a mentor.
Yeah, I was going to say the easier alternative is. I mean, like, for example, I go to Judge Hagerty for a lot of stuff. I knew him before Clerkland, just as a family friend, and so there's other judges that. I mean, Judge Arguello, for example. I mean, she will continue to mentor you, I'm sure. I don't know. I mean, that's interesting as far as the. I mean, Judge Webb, who you've met, I mean, he was kind of a little bit more that way insofar as, we wouldn't go out for drinks at the end of the day, which we'll do. My co-clerk and I will do with Judge Arguello. Definitely making that known that you want that. And, that's something that, to the extent that he responds, if you initiating is, it sounds like kind of going to be the best method. Yeah, I mean, perhaps, but also recognizing to a certain extent that personalities vary, and if that's not his personality, then,
or maybe it wasn't the clerk's personality.
Yeah, perhaps. But you might consider seeking such mentorship elsewhere.
There's a lot of, you've done a good job with that so far, but sometimes you have to be more proactive to get that mentorship. But Judge Hagerty is like Mr. Mentor.
Yeah.
So it's
born a mentor,
Right, yeah.
Yeah.
Right. Yeah, it's kind of funny that I go elsewhere. I mean, Judge Arguello, I talk to her about all kinds of stuff, but you can never have too many mentors,
Can you guys talk about your writing process? How do you get going? How do you get started? How do you make sure you complete it in a timely manner?
I'm pretty unconventional, so I don't know how helpful I'm going to be.
Go for it.
I've never really been much of a like, pre-planner outliner. I kind of, I kind of think it through as I go, and oftentimes my first draft is more or less the draft I submit. So,
So your process is kind of almost not a process in a sense.
Yeah.
It's sort of digesting and and then, yeah.
and I don't know why I do it that way.
No,
I've
that's
been taking so many classes and so many teachers who try to get you into a certain way of doing things, and I just need to kind of, so at the Court of Appeals level, and this might be true of the Supreme Court too, and Circuit Court, I interned actually on the Second Circuit one summer, so
With
Judge Hall, and that was actually very different than the Court of Appeals. But for my general process, I get the briefs, and the first thing I do is read the briefs at the appellate level, and after I'm done reading them, I usually have a lot of questions about the record because they're usually disagreeing about what went down to some extent. I mean, rarely do they blatantly misstate the record, but sometimes they'll, take sections and stuff. So I'll usually go through the record and kind of look at the most important parts. And then I put up a template with, the order that I want to address each issue. And I literally just start going through and start writing, but I do it very slowly. So, I usually start with background facts first to make sure I have all the background clear in my own head. Sometimes I'll do it last if I'm not sure what I'm going to need to include or not. And then I'll go through and insert the law for each section and each issue and research the law, and then...
So you're not taking the party's statement of the law as...
No, I actually rarely use, unless it's a specific issue where there's only a couple cases.
Yeah.
I don't like to use the case law that they cite because I feel like I don't like picking one, because usually, especially in criminal law where there's like 6 or 7 cases that say the same thing, I like to just pick my own. So I'll just go out. When it's a little more recent, sometimes they have, especially like the public defenders, sometimes will have sort of black letter law. I think they've been inserting that haven't updated in like 5 years. So even
it looks bad for a court to issue a decision where citations were lifted from one of the briefs.
Yeah.
It really doesn't look good.
So I don't know. I guess that's
Maybe
really
it's
not
obvious.
that
I was
helpful.
gonna say, unless you're the litigant, in which case it's awesome. I just totally agree with you.
Yeah, I mean, every once in a while, and maybe this makes me sound a little prejudiced, having also said that I want to be a DA, but I will say I have been a little appalled by some of the records I've seen in DAs. It's been a little disturbing, but the AG's office, generally, not always, but I feel like the AG's office, maybe because they see so many of the same types of cases, but I do find that the way they organize things is pretty, I can usually count on them to summarize things in a cohesive way, particularly if I have a brief on the other side that is very incoherent. I can usually count on them to help me out, but I have had...
Which teaches you a lot about appellate advocacy.
Yeah.
It's like work with the court. Make their job easy.
Yeah.
I would often start with the answer briefs in criminal cases.
And I wasn't going to say that, but I often do. Yeah. But I have, that said, I have seen some appellate the AG's office really screw it up. And not on purpose, but they're missing something. And sometimes when the DA's offices appeal, that can be a mess too. You always gotta wonder why the DA's office is appealing.
Process?
I often read everything through once, honestly, just to find out what the heck they're talking about. I echo Alex in terms of the quality of the writing is generally atrocious. I think you will all find, trial, appellate, frankly, probably the Seventh Circuit even. It's really kind of shocking. I heard Judge Timkovich recently say that he would give, I think it was a C-, it might have been a C+, but I think it was a C-. that's the grade he would give to the general writing ability of attorneys in Denver. Anyway, he was like, I'm not trying to be harsh. He was like, that's just
No, that's fair.
genuinely true. I mean, I thought going to federal court, that people would kind of take it a little more seriously, that, it's a little bit more like formal, and I mean, it's often very bad. So I will usually read through everything once, and everything can be, I mean, ironically enough, in the trial court, often a lot more than in an appellate court, for various reasons. But I will often read through all of it fairly quickly, just to get a sense of what is going on, and then read through it again. And I usually, with like a notepad, kind of do the issues, in a very kind of rough outline form, just to figure out what issues, if any, do I need to go talk to the judge about, and say, like, these are the main issues, we've dealt with this before, we haven't dealt with this before, and I, for time reasons, almost always talk to my judge after I've digested a case, I will go talk to her and say, like, these are the facts of the case, and she's usually familiar with it because she skims the stuff as it comes in. Say, this is the case, and if I describe the facts to her, she'll say, oh yeah, I remember that. I'll say, this is what's going on, this is, what I think we should do about it, and for the most part, we're on par, especially now, having worked for her for a while. Occasionally, Alexis and I had one, actually, where we went to talk to her, and she was like, no. We were like, oh, right. Very well.
What kind of issue was it? Like,
it was what was it, insurance policy? Yeah.
Like a death policy?
Yeah, Alexis and I agreed on the reading of this policy because both parties said this is how the policy should be read, and they reached opposite conclusions, kind of interestingly enough, and we brought it to the judge, and she was like, she's like, I can tell you guys never got life insurance, or whatever it was. She was like, this, let me tell you how these policies function, and she told us, and I mean, after that, it was kind of like, it made a lot more sense. I mean, that's the only time I can ever think of where, because you had written the whole thing, because I was like, yeah, go ahead, read it. Go ahead. And that was the only time I can think of where something was actually all the way written.
Made sense. It's not like our conclusion was totally.
No. I mean, yeah, but that was pretty funny.
Okay, so this is what happened. It was a policy, and the way the language read it, either way that either party did the math, it was higher than what the person had paid for his life insurance. So when he went to talk to her, he was like, you don't get more insurance than what you paid for.
Yeah, we're kind of like, that actually makes good sense. but the insurance company was even, I mean, they were like, no.
Well, and I think this goes back to a recurring theme of the level of advocacy, and there may be very many different reasons for it. I mean, you all are all good writers, and it's really hard to understand how many lawyers are incredibly poor writers. And if you're a poor writer, your reasoning's not going to be that strong either necessarily. And I don't mean to sound like a jerk about it, but it's just, especially when you're sitting in the court, you have the luxury of time oftentimes, right? And you have the luxury of the judge to refer to, and so it's a different situation. But I think, especially with billable hours, there's just a lot of pressure to not put together the highest quality work product. And I don't know. After my experience in the judiciary, I had some trouble going back to private practice. Because my standards were, and because I had a certain idea of how to approach the courts and sort of what was a viable argument versus not. And I don't know, I hope that doesn't happen for you guys, but.
I think one of the things that, I think ethically, I've learned so much about I think I will have the confidence to not listen to partners or, a supervisor, DA's office, whatever it may be, who, know sort of that, just have the confidence to know that not all lawyers are ethically sound, not necessarily blatantly unethical, but for example, we get civil appeals all the time that should not be appealed. I mean, they are bogus. They are completely, frivolous, and exactly what they're doing. I mean, either they have a really, really pushy client that they can't say no to, or they're giving them bad advice. And those have been situations where it has taken me a little bit of time to gain the confidence to say, at first I was like, I must be missing something here. Like, there's got to be more to this, And now I'm like, okay, this is actually not that uncommon for them to do this.
Well, let's say you're an appellate specialist at a firm, maybe you're going more the DA route, but if you're an appellate specialist at the firm and they're coming to you and saying, oh, we really need you to appeal this, and you see there's nothing there, what do you do?
Yeah, well, I mean, you can always make an argument for, changing existing law or, a new application of the law. I mean, I think public defender, the appellate public defenders have to do this
Yeah,
with
sure.
some
Yeah,
frequency.
Yeah.
Yeah, but I mean but you have to be transparent. You should be transparent about it instead of misciting cases or, just making up things. I mean, it's okay to say like,
Yeah.
we recognize the law
This is
is
the
as
rule, but-
follows.
right.
Yeah, but here's a proposed way to apply it in a different context. I mean, and then hope that your facts are such that you can cast
Yeah.
them as different from anything that's
Yeah.
come before. But
So I want to pause for a second and actually just kind of survey you guys. Think of what's a takeaway that you have right now from the conversation, something maybe you hadn't thought about before, just a different way of looking at things. Do you see what I said? Put it on the spot.
right, I actually had a question for him too.
Go with your
You want
question.
me to ask my
You guys-
question?
yeah, you guys
I
think about it.
I was going to ask, if you guys have thought, and I think you should before you start, what you'll do when your judge comes to you and says, I want you to, okay, so the opinion that you're writing in the Prop 8 case, whichever way you're coming out, if your justice that you're clerking for said, I want you to do exactly the opposite, and it's something, it doesn't necessarily have to be something that you're, have like a moral concern about, although that does happen. What are you going to do when your judge wants you to write something that you disagree with? It's an important topic because it happens. It'll happen to at least one time next year.
I mean, I think that there's a difference between whether you think the law doesn't go with it, or whether it's kind of an area of the law where it could go either way, and you would want to go that way, and they would want to go the other way.
Well, what would you do in either
Well,
scenario?
if I thought they were legally wrong, I would attempt to speak to them about that and
Yeah.
maybe explain it or find out why they thought it should go that way.
And that's a matter of tone, I think, that conversation,
Yeah. Right.
But if either side can be supported by the law, we kind of have to depend on how strong your conviction is, but I think at the end of the day, it's their opinion and their reputation more than yours, and so unless it's something you're fundamentally opposed to, but then you have to.
What if it was?
I don't know.
Think co-clerk. That's one. I think that's one real. Yeah. Usually it's kind of rare. I think to have, especially you'll have probably 3 co-clerks,
Yeah.
and the more co-clerks, the merrier. And insofar as if there's something where you're like, I cannot work on this project, or I cannot write this way. Like I think judges generally are like, I don't care who writes it, get the work done. And like you can trade. So
That's a good.
that's a possibility. That's the easiest one.
Any other responses to that question?
You definitely want to respect the judge, but I'd probably just ask what precedent cases he's looking at, or if there's something, if he can provide you with some information on the law that you didn't interpret the same way.
And
or if there's maybe a fact that you had a different perspective on too. So that way it's like not a blatantly wrong interpretation or fundamentally different than yours. It's like you're kind of just looking for a different perspective on it.
My whole thing is that deciding opinions as a matter of the law is not a matter of opinion, right? Or politics or what have you, and that's kind of a Pollyannish sort of outlook. But I think almost the harder situation is when the judge has the law wrong. And, how do you approach that in the context of this very sort of, respectful relationship? Do you guys ever do written memos to your judge about an issue, or?
I've never
Yeah.
done it. That's not true. I've given her, she'll ask for research summarized, we'll do that.
Okay.
But if she wants just my opinion, generally,
Yeah.
we'll just chat it out. But I've had a couple situations where I've never had a deep disagreement with my judge, but I've definitely had situations where I would probably have done it a little differently. We had one case, and I think this is a good example, especially on the appellate level where you're on division. So you're not necessarily just waiting for your judge. In some situations, it kind of becomes like trying to get everyone on common ground.
Yeah.
So I had a fun little case where it was an incredibly simple and incredibly complex case all at once. There were 3 possible alternative outcomes. It could be, we could get rid of it on mootness or procedural grounds. It was procedurally untimely. or the merits. And all three were pretty straightforward. It was, no matter what, it was going to be the first opinion I'd ever written. But each judge wanted to do it differently. And I had my judge convinced mootness. I was really excited about mootness because we don't get to do that a lot. And I really wanted to do that. But the other judges could only agree, and I think we ended up going on procedural untimeliness.
So there's a little
But
diplomacy there with the panel,
I kind
right?
of wanted her to, be a little more, come on, mootness, gotta do mootness. And, it wasn't an important enough issue to really.
Well, judges will sometimes fold on issues, absolutely fold on more profound issues to preserve relationships,
Sure.
because they don't
This
see
wasn't
this being.
particularly
Yeah.
profound. It wasn't going to change any
Yeah.
law or anything like that. But, that's just an example where, you pick your battles and I still went in and told the judge, I really think mootness is the way to go on this. I'll write either, I actually drafted all three for her to give to each judge just because they were like 3-page opinions each. But I would, and she was like, well, it's not worth me fighting with other judges over, like we're not doing it that way. So,
Yep.
Yep.
But so, think about that. Can you keep an eye on the time for me?
Yep.
What is it now?
8 minutes.
Okay. The tone of that conversation that you might have with your judge, if there's a rough spot, in whatever sort of way, how would you describe that tone?
This happened to me on my first day with Judge Arguello. She said, I want to remand this case sua sponte to state court for a procedural defect. You have to remove, if you're going to remove a case from state court to federal court, there's certain hoops you have to jump through. And the judge thought that they had to jump through one of them, and she wanted to kick it out without a motion to remand having been filed.
And district court judges also want to get rid of cases.
Oh yeah, they love to get rid of cases. It's like our favorite. Actually, I think it is our favorite thing to do.
Yeah.
Just to get things out of the way. And so I kind of started writing it, and it was going to be real easy. And then I thought, well, I don't know actually if the court has the power to do it sua sponte. And I did a little bit of research. It was like, for procedural defects, you're not supposed to do it sua sponte. For jurisdictional defects, the court has an obligation to act on its own initiative. So I was like, because that was something that the judge hadn't mentioned, like that was even like an issue. So I went in and talked to her, and I was like, Judge, this isn't done really. And she was like, I'd like to do it. And it was my first day.
She's like, you see the rope?
Yeah, she was like, I'd like to do it, find out if it has been done. And so I was like, okay. So it took longer than I had anticipated, and I did a lot of
You're like
research.
2 a.m. your first night.
No, it wasn't that bad. Sure enough, I found some instances in which it had been done, including once in the District of Colorado by a judge that's still an active judge who's still sitting, which made it very easy. And there was decent reasons given in that order, and I adopted them. We followed them.
And that didn't hurt the relationship between you and the judge?
No, in fact, it was so much the better because, I had thought on my own. I had pushed back a little bit. She had told me, no, I still really want to do this, find out if we can do it. And I found out a way, and she was really happy with that.
She knew she could trust you to point out
Yeah,
why this
yeah.
might not be the decision.
Well,
Don't
no.
let your judge walk into a trap. Man,
Yeah.
that would be
Right.
bad. Yeah.
And then ultimately that I would, do what she asked.
Yeah.
It's a difficult conversation when you disagree with your judge, I think, to say that, but I don't think it's uncommon for a judge to test you early in your tenure with them. Not like purposely, but because, they're the boss and, they, might feel the need to assert that with their clerks, as they come in, just kind of set the relationship right, which I don't think is all bad by any means.
What do you guys want to cover in the last few minutes?
I'm really curious about what you are allowed to do and not allowed to do with your political affiliations or we talk a lot about ethics and the standards that judges are held to, and I talked to one of Justice Hodges' clerk and asked her the question of, are the clerks held to the same standards as the judge? She said basically yes. But I'm curious about your perspectives dealing with different judges and what you really need to watch out for ethically, personally, and what's not a really big deal.
Definitely judge by judge again. I think Judge Fox, again, is more comfortable being involved in various organizations than maybe some other judges might be. So she's been pretty, I mean, she actually encourages me to get involved in lots of different things. I mean, that
What kind of
said,
things? What kind of things?
yeah, like Colorado Women's Bar Associations, Intercorp,
You're not canvassing for
even like-
political
Yeah,
Yeah,
like,
yeah.
yeah.
I mean, anything blatantly political, don't get involved with while you're cooking, you can do it later in your life. But other organizations that may have a left or right leaning, my judge is okay with. I mean, like, you know, I'm involved in things on both sides, so I think that helps too. But still, I mean, it's judge to judge. I mean, some judges wouldn't want you going to an ACS thing, and other judges would be fine with it, for example.
That's
Yeah.
interesting. Example.
It becomes tricky. I mean, one instance in which it becomes tricky is when you start applying to firms, and this is what I'm experiencing, that appear regularly before the judge. You know, I'm like meeting with people that I've seen in court the previous week, and it's like, you know, so I mean, I had to go get out the handbook there's a handbook for law clerks and ethics handbook for law clerks.
For like the federal courts? Or
Yeah, it was
okay.
given to me at orientation,
Okay.
and yeah, I had kind of breezed through it when I first got it, but I looked, like, what do I actually have to do? And I was sort of surprised that, at least for me, and my judge was fine, she basically said, just do whatever it says. Tell me what it says and then do it. And it was basically, you're fine until you receive an offer from a firm or feel like you are about to, which is kind of a hilarious thing to say.
Yeah. Feel it.
At which point you inform your judge and you're kind of screened off from
I see.
cases from that firm. But yeah, that's one. But I think no matter what you do, you know, like I participate on the Civil Rights Committee of the Bar Association, and I asked my judge, you know, I think I had already joined before I started with her, but, you know, I said, I'm on this committee, do you have a problem with that? And, you know, she didn't, and I mean, if she had, then I would have, you know, put it on the back burner. Or I guess, I mean, stopped being on the committee or whatever. But yeah, there are definitely resources that you'll get at your training. I think the Court of Appeals and Supreme Court are kind of better at that than in federal court because the federal judges are all, like, they're kind of in each a court unto themselves. And that's, I guess, the beauty of life tenure and guaranteed pay. So, yeah, but asking your judge for sure.
Yeah, and definitely ask anything that has you giving legal advice. Probably don't want to do. Like legal aid committees, sometimes you end up doing that.
On the flip side, though, you can represent family members. I represented my brother in county court last week.
How'd it go?
The cop didn't show up, got dismissed. It was-
Very good. Obviously, that was due to your skill.
Yes. No, actually, there's some truth to that because we set the case when we went for the arraignment, and we were allowed to set it any time within speedy.
Yeah.
And so I set it for the very end of speedy trial. Because if the cop couldn't show up, then they'd have to dismiss it. And they did. So there was
Yeah, that's good.
some piece of strategy
Yeah.
involved.
No, that's
We weren't- I mean, I wasn't going to let it be.
I'll get you hard.
So. Yeah, it was sweet though. No, he didn't show up.
That's great.
Yeah, so knowing things like
I
that.
mean, you can't
yeah,
practice,
it's
right,
fun.
you generally cannot practice law while you're working for the judiciary.
Yeah.
With that type of
Yeah.
exception, so.
Right.
Okay, any last words?
I just thought of something else that when you said, you know, things when you started that you wish you know before. You are your judge when you're drafting. So like they're the author. So I think I've forgotten this, but I have completely changed the way I write to write like Judge Fox. So for example, I never used to use footnotes or parentheticals. Judge Fox loves footnotes and parentheticals.
Fascinating.
That's, you know, her thing, and that's how she likes to write. So I've completely adapted to that, and I'm fine with that. But you have to kind of let your independence go in that way. I mean, kind of, you know, she has a whole bunch of things she doesn't like. Like she doesn't like using the word both. So like I have all these little yellow sticky notes.
Okay, I was wondering if she had a
Circle.
style sheet for herself. or
I
you just
should
sort of-
put it together for
Yeah, you should.
my replacement
Very
law clerk, but it's just little like weird things. She doesn't like the word
Clearly, my judge hated the word clearly.
Yeah, they're just like little words she
Yeah.
doesn't like, you
Yeah.
know? So, you know, just keep in mind that some of your independence and your voice, you gotta just like let it go.
And not only that, to the extent that you can read opinions or orders by your judge before you arrive, it's kind of tough to discern their writing style until you start writing that way. But there are certain things I think that you'll pick up on. I mean, for each of you in your judge's writing style, particular, and less so, I think, at the trial court, because the volume is just so much greater that I think there's a lot of things where you're kind of like whatever. But I mean, from an appellate perspective, there's the judges, I think, generally assert themselves, their voice. I mean, yeah, that was certainly true with Judge Webb. I mean, he beat things into me, which is kind of funny, because then as a result, if you like him, you incorporate him into your own writing style, and it's pretty cool. But you know, if you can pick up on those things and read, I mean, don't overdo it, but if you can read stuff that your judge has written before you show up, there's some utility in that.
And just to recognize that that's your role, you know, and again, I think it's just it's a really uncommon role in today's society to really kind of subsume your personality within this other crazy. Right, but it's that is part of the package, and if you understand that going in, then you can, you know, do a better job for your judge. So this was great, guys. Thank you so much. So thank you for coming.
Yeah, thanks for having us.
Wonderful. Thank you very much.
Sure, yeah. Nice to see you guys.
Feel free to,
They're good.
how old are they now?
Almost
Ask any other
5,
questions, guys.
2.5, and then third one
That's
in
great.
June.
Oh, congratulations.
Thanks.
Yeah.
It's just
Yeah.
hard that.
You know, it's a boy or
Girl.
Okay.
Yeah,
Great.
Charlotte. So.
Oh,
Alexis.
Yeah, we
Yeah.
we're just crazy busy.
You're with Rachel next year?
Yeah,
You met her, she's so
I'm
great.
happy to.
She's awesome.
Guys, I gotta run. See you next Monday. Okay, so we don't have class on Wednesday. I'll see you next Monday. Okay.
We'd be having
Yeah, and
before
I would say
going to a
in
new job.
personality,
Yeah,
wise,
definitely.
she's probably similar to Webb that way.
Yeah.
He's
You know,
really
I
quiet.
completed all my interviews at Brown State. You're
Really?
supposed to
Oh,
tell
he
me
wants
this
you.
week.
Yeah.
Yeah. So,
Do you feel like you're about to get
exactly right. I know, that's what I was like saying. I feel like I'm about to get multiple offers. It's like, no.
You're like, you can rolling into it, going, I have to recuse myself.
Yeah,
from everything.
exactly.
Let me get off first.
That's actually not a bad idea.
Yeah.
There's a couple of firms
They'll be the first
that
one
would be
in.
tremendously
Super
helpful to me.
like.
But we
You
would,
know?
I mean, you're still going to go there, right?
Whereas
Oh,
Judge
yeah,
Webb-
well, after my clerkship, I am,
So-
I own Stapleton.
I think
Was
we're
it
going
this is
I was
interesting
like, that's
interview
my first,
process.
and then I was like, I own Stapleton.
Yeah.
Oh, man, I was all excited. I was like,
Yeah.
if I go there.
I know,
And
I
I
know.
know, you know, I
Is he,
think
did he
so
ever
much
win?
about like.
So that was his
That's
part.
what's great, all the judges like. It's really funny that you mentioned Wheeler and Trey.
Let's go, man. Jerry's.
As I was walking here, I saw, like, ended up rather.
I did not have judgment.
Who's that?
He'll be great.
Yeah, I feel like I'm probably.
So, when she updated it,
don't have it yet.
I'm not gonna.
I guess I
So I made the determination.
I didn't talk to her, so I don't know.
I feel like a lot of the.
Yeah, I interviewed there on Friday, and she's not there. No, she's not. I mean, we would probably be like that.
Yeah, probably Barbara.
Interesting.
Yeah.
I had a lot of answers where
Yeah.
it was really close, like
That's crazy.
the most ethical no because and the least
Yeah, we were-
ethical yes. I was like, I'm not
Ron
gonna
Steve.
between those two.
Yeah.
I was like, I saw the issue here, and I'm like,
I mean, John.
you know,
Yeah.
about
Yeah,
this
he's-
may problems, but I.
Before
Some of them just like
him,
really down.
I met with
Yeah,
Keith
we're
there,
around.
who's kind of a friend of mine.
So that's
Oh, and
facts
so
that most aggressive.
Kristen, who was,
Yeah.
Really had to
so
figure out which one.
Kristen's
Yeah.
sister,
Yeah.
who's a
Yeah, I was
lawyer,
Right.
was
like,
like,
I this been like this.
Yeah, exactly. That's how I met
August,
Kristen.
date nailed down yet.
You guys are so social.
Yeah.
Like 6 degrees
like,
of
it was not.
separation.
Yeah. So I met with her and then G. Howard
Yeah, you guys are not.
and then John McDermott.
Yeah.
John Gray.
I wish I could give myself
Carl
that
Shaw.
sooner.
And then when I went back, it was like
It's a good
Yeah,
feeling.
pretty trees.
You know.
Yeah, no, that's how I felt too. I was
Judge
like,
Webb
no, I
was
feel like all the
just
laws are like,
and
internship,
then
it's whatever.
associate at HR.
It's just
I mean, every human being I've ever met knows John worked for him at some point. Yeah, so I walked in.
When you start having
Yeah.
this
But then
Yeah, oh, you know John? I'm like,
Yeah, I.
oh, Webb? He's a student of mine. It's like,
Yeah.
But yeah, I mean,
Let's
it's like, I
choose,
felt
like, chemical
it wasn't
plants.
everything. It was a lot. Well, we'll see.
Oh, yeah.
Yeah. I really thought you were going.
Choose my husband's online.
Yeah.
They're pretty
Yeah,
good.
that's also really
I
nice.
know.
I think
Yeah.
the work with John McDermott.
You get it.
Yeah, it seems like a nice.
I forget how much I paid. I think it varies.
Gosh, that's crazy. Yeah,
depending
we trade
on
is just
you.
blowing up. There's so much work. It's unbelievable.
Yeah, I
But
really
it's
need to
pretty
like
shitty.
catch up with Cindy, but I saw
Yeah.
I'm trying to think.
That is crazy.
Gosh, gets to
It's
direct.
very
back
interesting.
into
It's very
it,
interesting.
especially when
I
we're
mean,
younger.
obviously, for
But I think it also
my own
started
prospects.
like
I mean,
earlier,
people, prospects
like
of
even
meeting
after
people,
I
which
had
is
to play
simultaneously
football.
discouraging and encouraging.
I know,
I mean, on the one hand, they're gonna have to replace